This webinar, we're going to be focusing around how to ban the box. And this is, as I mentioned, this is the fourth in our series of ban the box webinars. And in the first one, we looked at the legal stuff and some of the technical requirements around recruiting people with criminal convictions. In our second webinar, we then looked at when and how to ask about criminal convictions if you're not asking at the first stage of the application process. And then in our third webinar, we looked at how to respond to the disclosure of criminal convictions. And what we're going to try and do today is bring all of that together. We're going to touch on most of those points, but we're really going to focus on bringing it to life with some case study examples from the three businesses that are joining us today. So I'm really, really delighted that we have with us Juliet Colden from Freshfields Brookhouse Derringer, who are the first law firm to adopt Ban the Box towards the end of last year. We also have Richard Buxton, the HR Director from the South Bank Centre, who are our first arts organisation to support the campaign. And we have John Hardy and Alison Latham from Alliance Boots, who were one of our earliest supporters of the campaign and heavily championed it at the launch. So each of those three case studies will give you a bit of a flavour of the different approaches that those companies have taken in adopting Ban the Box. But by way of background, for those of you who may not be so familiar with the campaign, we launched Ban the Box in October 2013, and the aim of the campaign was around levelling the playing field for people with criminal convictions and giving them a fair opportunity to compete for jobs based on their skills and experience. And through the campaign, we ask UK employers to do two things. We're asking them to remove the tick box from job application forms that asks about criminal convictions. And this is really important, we're asking them to, in doing that, consider people's skills, experience, ability to do the job first, before asking about criminal convictions at a later stage, if at all. And why are we doing all of this? Well, the scale of the problem in the UK is pretty significant. It's not a niche issue we're trying to tackle here. There are 9.2 million people with criminal convictions in the country, and a fifth of active job seekers represent that population of people with criminal convictions. And we know that with really quite critically high reoffending levels, employment plays a really important role in reducing reoffending, which in turn reduces costs to society, costs to the economy. So it's undoubtedly a good thing to be encouraging. However, what we do know from research is that employers are actually using the disclosure of criminal convictions and the tick box to screen out employees. Some employers, so 1 in 7, the research shows, would reject any applicant with a criminal record, irrespective of whether or not the offence was actually relevant to the role in question. So it's a blunt instrument that's being used to filter people out at that first stage. And by being a blunt instrument, the tick box itself really gives no opportunity for job applicants to contextualise or explain the circumstances around their conviction and what's happened since, and indeed give the opportunity to the employer to actually really make a balanced decision on whether or not their conviction genuinely does pose a risk or is indeed relevant at all to the role in question. We also know from all of the individuals we've spoken to over the years at Business in the Community that the tick box puts people off applying for jobs. They think, I tick that box, I tick yes, no one's going to come back to me, no one's going to respond. Or it can even encourage them or lead them into actually not being as truthful as they could be, which isn't a good situation for either the employer or the individual. And then finally, and probably most importantly, it means that people who have the right skills and the right talent and motivation to do the jobs are missing out. And so employers are missing out on talent and skills and committed employees. So it's a lose-lose situation for everyone, and that's the thing that we would like to see change through our campaign. Individuals are at the heart of the campaign. Business in the Community, we've been working with people with criminal convictions for many, many years now through our Ready for Work programme and other campaigns. And the reality is that all of the people that we speak to as part of our programmes and campaigns tell us how desperate they are for just a fair chance at employment. So it's not about positive discrimination, it's about giving people the opportunity to genuinely rehabilitate and contribute to society through employment. So, the first of our interactive polls, I'm hoping my colleagues here are going to help me with the technology. You'll see in front of you there's a question, a true or false question, and we'd like you to use the panel on the right-hand side of your screen to respond to this question and tell us whether you think it's true or is it false. So the question is, anybody with a criminal conviction must always tell an employer about it when asked. Do you think that's a true statement or is that a false statement? I'll give you a few seconds to respond and then we'll see how people are doing. Okay, well, interestingly, we have 56% think that it's true, and the remainder think that it's a false statement. And the answer is actually that the statement's false. So there are elements of truth in it, in the sense that when asked, people with certain convictions are actually legally obliged to disclose, but it's only for a certain and very specifically defined period of time that's defined by the Rehabilitation of Offenders Act. So it doesn't mean that always they must tell someone. So not everybody and not always is the answer to that one. And I'll come on to tell you a little bit more about why that is. So before you reel with boggled minds at the amount of text on this slide, I just want to explain what I'm hoping to do with this, is just share with you some of the definitions of some of the key terms that you may well hear through the case studies coming up shortly. There's a lot more information about all of these different terms and explanations on our website and our resource bank. But the key terms I just wanted to highlight briefly were spent and unspent criminal convictions. So depending on the length or type of sentence, if a certain time has passed, some individuals no longer need to declare those convictions for most purposes, so jobs, insurance, that sort of stuff, and those convictions are then deemed Those convictions are then deemed spent. The individual no longer needs to declare them. Unspent convictions refer to those convictions for which the individual is still within the time period defined as the rehabilitation period, during which they do need to declare those convictions if asked. And important to emphasise as well that some convictions will never become spent, so the individual will always need to declare those. The other terminology I just wanted to pick up on here, you see running down the left-hand side of the screen, is regulated and unregulated roles. So in essence, the Rehabilitation of Offenders Act that was passed in 1974, it sets out a group of roles that are defined as unregulated, for which the Act covers. So that means that people don't need to declare spent convictions if they're asked. However, for regulated roles, which are the roles in the two rows at the bottom of this table, individuals applying for jobs in those industries will need to declare spent and unspent convictions. And there's a bit more information on the right-hand side of your screen and also at the link at the bottom of your page. And then finally, just a very, very quick overview of criminal records checks. Important thing to emphasise here is the majority of jobs in this country are unregulated roles, and there's no criminal record check legally required for any of those roles. However, employers do have the right to request a basic disclosure, and that's a check that's conducted by an organisation called Disclosure Scotland, and it covers the whole country, and that looks at unspent convictions only. For regulated roles, there is the opportunity, and actually in most cases organisations are required to conduct a DBS check. And that's, for those of you who may have been familiar with the old CRB check, so it's a similar thing, it's essentially the new language for that, and it stands for Disclosure and Barring Service. And now for these roles, those DBS checks will show all convictions, whether spent and unspent, unless filtered. I'm not going to go into filtering on this webinar, but please do check out the link at the bottom of this slide if you'd like any more information on some of the terminology. But hopefully this will help you understand some of the case studies that will be coming up shortly. In our second webinar, we talked about actually if you don't ask about convictions at the first stage of the application, when should you and how should you do it? And I did just want to pick up on that very briefly now, because there's no single right answer to this question. Employers can ask after application, before interview, at interview, job offer stage, or indeed never. And really the important thing here is to think about what's best for your recruitment systems and needs. And some of the examples that we're here today from the other businesses will give you some flavour of the different approaches that others have taken. And in terms of how to ask, again, a number of different approaches. For some roles, you will need to do a DBS check, and those are the regulated roles. However, for the majority of roles, it's really down to employer discretion of how they ask. We would recommend, if possible, that you do give people the opportunity to disclose in writing if they're going to be asked, even if you are then going to talk about it with them. This just gives them a little bit of extra control over how they disclose and gives them the opportunity to do that most positively. And then once somebody has actually disclosed a criminal conviction, how do you respond to that as a recruiter and as an employer? And just a few points I wanted to highlight here. The first is, of course, remembering the applicant. So really important to manage people's expectations, and if you're going to ask about convictions, tell them up front if, when and how they're going to be asked about that. The second one is around equipping recruiters. So actually the most important thing I would emphasize here is that once you've given people the right training, policies and guidance to fairly assess information and feel confident to do that, you also need to give them the license to hire. So as a business, if you've taken the decision that you're going to take people on a case-by-case basis, then recruiting managers need to be given that sense of support from the business that they are able to hire people with criminal convictions once they've gone through the policies and the process that you've set out for them. And in deciding whether to hire, again, just emphasising that processes must be consistent and informed and really should consider the real risk and relevance of each criminal conviction rather than leaving it down to individual judgments, which I think is where there becomes a lot of opportunity for misconceptions, preconceptions and fear-based decisions to come into play, which don't necessarily act in the best interest of the individual or the employer. And then finally, once the decision has been made, important to tell the applicants why that decision has been made. So if they've not been successful and it's because of their conviction, then explaining that to a certain extent so they understand. But also thinking about if the applicant's been successful, who else needs to know within the business? In many cases, no one else needs to know because the decision's been taken by HR and the risk has been reduced or minimised or ruled out. However, in some cases, it may be important that the line manager knows. And in these cases, it's always important to make sure the applicant knows who else knows about their record. So our second poll, just testing your knowledge from that slide that came up earlier. Again, another true or false question, and please do use the panel to the side of your screen. And the statement is that employers can choose to conduct DBS checks, which were previously known as CRB checks, on candidates for roles working directly with the public. Do you think that's true or do you think that's false? We'll just give you a few seconds to respond. Okay, so 60% have said it's false, which is great because it is false. As we covered a little bit earlier, DBS checks can only legally be requested for candidates working specific roles that are excluded from the Rehabilitation of Offenders Act, so these regulated roles. And this may well include some public-facing roles, but it doesn't exist as a category in its own right, so it does need to be checked out on a case-by-case basis. So over to the businesses who've supported the campaign. We've been fortunate to have 21 companies who've already banned box, and within these companies they employ nearly 200,000 employees. That's 200,000 roles that have effectively been opened up and made more accessible to people with criminal convictions.